All right. Welcome, everyone. My name is Kirsten Loita. I head up our university relations team here at OUP. I'm so glad that so many of you are joining us for this fifth and final webinar in a series of webinars on academic startup licenses. Some of you are returning to us. Thank you so much for joining us again. And some of you are joining us for the first time. So welcome to this series. If you haven't watched our previous ones, we'll talk about how you can do that in just a minute here. So we have our three returning panelists. I'm going to go forward 2 slides here to get to our pictures of our panelists, and we're going to have them each introduce themselves. Nikisha, we're going to start us off with you today.
Good morning. I'm Nikisha Holder, an Associate Director of Licensing at Johns Hopkins Technology Ventures with a focus on life science-based technology. I'm pleased to be able to share information on this platform for an industry that has been so rewarding for me personally, as well as for the general public. In particular, I'm glad to provide information to startups, entrepreneurs that are new and experienced related to how to work with universities. Our goal is truly to ensure the technologies are paired with the best partners and further to facilitate a course for successful commercialization of products that will benefit patients and the world. I want to thank OUP, Lisa, and Rick for working with me as a part of this panel. Although I'm conveying a lot of information to our audience, I have learned so much as a participant. So thank you all.
Thank you, Nikisha. I think we all feel the same way. Lisa.
Yeah, thank you, Nikisha. That was a fantastic intro. And yes, it's been a pleasure to be part of this webinar series and get to work with and learn from you all. So I'm thrilled that I got to be a part of this. I'm Lisa Norton, Director with CoMotion, which is the University of Washington's Tech Transfer Office. And I'll be representing the public university perspective today. After working at a local startup, I joined our office about 17 years ago, and my portfolio that I manage is primarily medical device technologies. I've always been really interested in applied research and how best to get research from the benchtop out to the public. And certainly working with startups is one way to do that, and having this webinar series as a resource is something that I think is going to be fantastic. And thank you all for being a part of it. If this is your 5 of 5 watching the webinars, we've really loved how engaged people have been. And I hope that that's going to be true today. We'd love to hear your questions and help answer them. So thank you, and thank you, OUP, for this opportunity.
Thank you, Lisa. It's been such a pleasure. Rick.
Thanks, Kirsten. I'm Rick Friedman. I'm with Novus GC. We serve as general counsel for early stage technology and life sciences companies, guiding startups through angel and venture financing, licensing, and other commercial and personnel contracts, as well as helping startups get formed. The 30,000-foot summary of my prior experience includes Silicon Valley, big law, in-house general counsel roles, and a 9-year stint in tech transfer, first at UT Austin and then USC. And so I've been involved in tech transfer now for 16 years. So 9 years at universities and then 7 years as counsel representing startups or other licensees. And I think Kirsten, you may be covering this already, but a large impetus was this in both roles, both at the university and as counsel. There's a lot of new things that are just different about the way the university licensing process and the agreements work, that I found myself, and I know others on this, the other panelists, frequently are going over the same kind of similar territory with people who are new to tech transfer. And I find myself in the same role when I'm working with founders of companies. So we are truly hopeful that this will this series will be a useful resource to providing more context for folks going into the licensing process. And I want to ditto absolutely everything Nikisha said, and it's been a real pleasure on this. And it reminds me, doing this and working closely with folks who are spending every day working on tech transfer, just reminds me of both the complexity and how hard their job is and the different things they have to manage. And also there's just an never-ending array of interesting technologies and interesting issues come up when working in tech transfer.
Thanks, Rick. That's really, and I think that does provide really good context for this series and why we, why we established it. And I really want to express my deepest thanks to all of you, to Lisa, Rick, and Nikisha, for the tremendous amount of work that you have each put into this webinar series over the past many months. It's been almost a year since we started conceptualizing this series. Then establishing the goals of the webinars, and then parsing out the topics into these 5 different webinars that we developed. And you really have devoted such an incredible amount of time developing this content. So thank you again all so much. And I really could not have asked for a better group of people to work on this project with. So, and we hope that this series really did accomplish our goals of educating people about the university startup licensing process to help create these better relationships for all involved in the academic innovation commercialization journey. So thank you all. We're just going to move on really quickly here. We talk about this each time just to give people an overview of OUP in case they don't know who we are. We're a venture capital fund that invests in academic institutions, startup companies. We invest in all sectors of deep sciences. We invest in seed to pre-IPO rounds. We actually, part of our profits then are provided back to the universities. We also have a lot of other benefits for the academic institutions we work with as well. We are on our 3rd fund now. Across our 3 funds, we have approximately $600 million under management. And we've invested in, I think it's something like 125, maybe even more now, spinouts associated with academic institutions, a lot of which have now IPO'd. It's obviously been a tremendous time for IPOs in general, but particularly in the biotech sector, and a number of great successful acquisitions as well. And we have a large team that works on all of this, and it's working with these academic institutions that we learn about our opportunities. So both from those of you who are on the tech transfer side who are watching this, as well as those who are perhaps on the startup side, we're interested in learning about your startup companies. So thank you for working with us and watching this today. We look forward to hearing about more opportunities. All right, so let's move on to, we are recording this presentation. You will find it afterwards, both on our partner portal, which our tech transfer folks have access to, as well as the researchers at their institutions. We now have a section of our partner portal that is accessible to our research institutions. And then we also record this and put it up on our YouTube channel. We're gonna have some links that are around in the presentation that we send around. But the other thing that I wanted to mention is Q&A. We really do encourage questions. For those of you who have seen our webinars before, absolutely ask us questions throughout this. I will be moderating those questions and asking them of our panelists as we go along to the different subjects we're covering today. So with that, on to our next slide. This is our 5th and final session, as we mentioned. We're talking about the lawyer parts today: confidentiality, indemnity, warranties, liabilities, et cetera. I'm going to go over this in just a minute when we talk about the agenda, but you can find all of our previous sessions on YouTube at the links when you receive these slides, for those of you who registered for this beforehand, and on OUP's partner portal that I mentioned before. And if you don't currently have access to OUP's partner portal, and you are either with a tech transfer office or an academic entrepreneur researcher at a research institution, just contact us. We'll give you some contact information at the end of this series to do so, to register for that. So Rick already very nicely went over our purpose and approach. So I'm not going to go too much into this, just to save us some time, because we typically run long and do not often have time to get to every single question. So I'm not going to go into this too much, but really just a reminder that this is about building relationships, and negotiations as you go through them are a process of discovery and discovering what each side is important to each side. And so figuring out some of those things that are important to each side early on really helps your relationship, and negotiating a great deal in the end for all parties. All right, so I'm going to go on to the agenda. As I mentioned, we're going to first cover confidentiality. Lisa isn't going to cover this because we didn't actually get to it in the last webinar, because again, we went long as usual. Then we have a risk allocation section for today's agenda. We'll go through indemnities, insurance, warranties, or actually the lack of warranties, limitation of liabilities. Then we'll talk about patents and the patents that are being licensed, about ownership, prosecution, expenses, enforcement, and validity challenges. Then we'll talk about dispute resolution and name use, finally, to wrap us up in this series. So with that, let's move on to Lisa and confidentiality.
Great. So I think that licenses are occasionally thought of as sort of a sales receipt or a one-time transaction where you simply take your technology and go. But I really hope that over the course of this whole series that we've emphasized how important it is and valuable it is to really have great communication between the university and the startup. So that really benefits both parties, and confidentiality clauses are an excellent way to enable that kind of broad communication and cover information while making sure it's protected. And some of the things that we want to make sure that are included in those confidentiality clauses are things like research progress updates, business development updates, whether the startup is working with a new partner, is that a sub-licensee or distributor, information about the business of the startup, and financial reports. So all those materials that get shared between the parties over the course of the license agreement are under that umbrella of confidentiality. And again, that's just a great way to really facilitate open communication. There are definitely instances where some information may be exchanged with other third parties, and those are generally called out in the confidentiality section as well. One of the times is that the university is going to be excited about the fact that they have this new agreement, want to talk about it and do so with their board. But when doing so, they're not talking about the financial terms of the license. They have the ability to talk about the fact that there is a license, what technology has been licensed, and to which company. One of the things that can be unique to public universities is that many of us, including the University of Washington, are bound by different public records acts, where if we get a request, we then have the onus is on us to provide information to the requester. In a limited number of times where that happens and the request is about one of our license agreements, we have the ability to redact quite a bit of the information within that license agreement to protect our licensees' confidentiality and competitiveness. And if in any case, the company doesn't feel as though we've been able to redact sufficient information, they also have recourse to be able to do further redactions. So again, this is something that happens in a very limited number of cases. I'm identifying it here in case you're working with a university that would have similar language. And then importantly, companies certainly also will need to discuss different parts of their license agreements with their partners. So that could be acquirers, sub-licensees, distributors, any other parties that may be interested in doing business with that company. And the confidentiality language will call out that ability to be able to have those discussions. And also often in the clause, it'll also indicate how that information will be conveyed, whether or not there's a marking clause, meaning are only communications marked confidential, considered confidential. And so look for that, make sure that that's something that you can comply with and that you understand in signing off on that component. And really, this has been an essential way to make sure that in all the communications that we have, both parties feel very comfortable in sharing their information. And now going from confidentiality, we're going to switch gears a little bit as Rick introduces the provisions around both risk and risk allocation.
Great, thanks, Lisa. Next slide, please. There are common provisions included in commercial contracts to allocate risk between the parties. And as Kirsten mentioned a couple slides ago, these include reps and warranties or disclaimers of warranties, indemnification provisions, insurance requirements, and limitation liability clauses. In the next few slides, we'll look at each of these in a little more depth. When two companies enter into commercial contracts, there often will be an expectation of mutuality regarding these provisions and shared risk based on the contributions of each party to the relationship. When universities are party to a contract, however, the equation is usually different. Universities in general will accept very little risk. From the university's perspective, their mission is research and education. Licensing is an important channel for disseminating research results, but is ancillary and can't put the core mission at risk. And beyond that, they see the startup bearing that risk as the appropriate balance, since the startup, not the university, controls product development, manufacturing, and sale. Also, universities often have very deep pockets and are concerned about being the targets of lawsuits, and so have standard contracting practices to mitigate that risk that are instituted broadly across the institution, not just in the tech transfer office. And those policies and practices end up being reflected in the license agreement. And then finally, when dealing with state universities, there may be statutory or constitutional limitations on accepting risk. For example, many state agencies interpret state laws forbidding or restricting them from providing indemnification. From the startup perspective, we counsel clients that if they're thinking about the long term and planning to raise financing or be acquired, the economic terms of the license are going to matter a lot more than the risk allocation provisions in a university license. It is important that the startup understand how risk is allocated, and there are some provisions that they may be able to create some more balance on. From a big picture perspective, though, unless the startup has a lot of funding and isn't in a hurry to get the license done, most will choose to accept these provisions largely as is, subject to a few areas of common compromise by universities. Otherwise, you can end up burning a lot of calories, time, and money negotiating provisions that you have little chance of moving the needle on. And you don't have to take my word on this, though. There are hundreds of negotiated university licenses made publicly available through SEC filings. And while the economic terms of those are typically redacted for confidentiality reasons, the risk allocation provisions usually are not. And by looking at a sample, you can get a sense of where there's flexibility on these provisions and where there isn't. And a final point I want to make is there's a reason that today's slides are called, I think Kirsten calls them, or they've been dubbed, not just you, Kirsten, who named it, the lawyer parts. And that is that while the tech transfer office will negotiate the business provisions of the license, deviations on these lawyer parts, the risk allocation provisions, will typically need to be reviewed by the Office of General Counsel or outside counsel or whoever the legal office is that's responsible for the tech transfer office. And it's not something often that's in the discretion of the tech transfer office to negotiate. Any comments from? If no other comments, then
actually, I'm gonna. There is a question.
Yep.
And it's tangential, but is it okay for the licensee to share the complete license from a state university with their investors, or only redacted copies? And I think this question maybe goes back to you, Lisa. So.
Sure. Yeah, great question. So that typically is called out as an acceptable way to transfer the agreement. So a non-redacted agreement, that's one of the things that would be in the confidentiality clause, having it be a fair use of that transfer. So typically not. This is the redacted part is in that special case where anyone can request an agreement from a public university. And so then we're able to redact the unique clauses within that agreement. So typically that's the financial terms around diligence. But as Rick is saying, there's standard language that isn't going to be redacted. So same in a public records request as it would be in some of the licenses that you'd see in an SEC filing. But yeah, it's expected that in those communications with people who are going to be investing in your company, that they would need to see more of the license agreement, and that sharing of the license with them, if you're sharing the full license, is done under confidentiality.
Great. And then we have one other confidentiality question. It's whether you have, excuse me, any of you have been involved in litigation around confidentiality. And the comment is confidentiality clauses seem to be taken somewhat less seriously in a university environment than in a commercial world.
I have not.
I have not, and I will say that we certainly take it very seriously. We don't share, we don't convey our licenses to our researchers, for example. We don't share our agreements outside of our office. And that holds true for any of the reporting that we get back from our licensees as well. That's all kept very closely within just our office.
I was one of the universities that I worked at. There was a confidentiality / trade secret lawsuit, but it had to do with actually what one of the researchers did, and one of the researchers taking some work that was done in the lab and then filing patents on it elsewhere. So that's the context. And I do think, I mean, those tend to be more where litigation is around on confidentiality. It's on the trade secrets than on disclosure of things that are in agreements, in my experience at least.
Yeah, I'd agree. So more things that come up in collaborations or sponsored research potentially, but we haven't had that happen for a license.
Great. All right. With that, then I'm sorry, Rick, I blew your thunder as far as moving on to the next slide.
So indemnification is a part of the risk allocation that Rick was just talking about, and it's defined in this way. So to indemnify another party is to compensate that party for losses that they've incurred or will incur as related to a specific incident. So if some incident happens, then it's all about who is going to be covering that incident. And one of the important things is that in reading through licenses from universities to companies, that's not mutual. And I want to talk about the rationale behind that because it's important as to why it is one-sided. And that's that in a license agreement, the expectation is that in the transfer of technology, the product development is then going to be done really wholly by the licensee. And whether that's at the licensee's site or their sub-licensees, or they might have an OEM who's doing that work for them, the expectation is that product development isn't going to be done under the license by the university. And for that fact, the risk is very different. So the university is not part of that product development. They're not, manufacturing on behalf of the licensee. And so they want to make sure that if there's an incident that happens in that product development, that since they're not a part of it, that they're indemnified. And I'll say that one of the times that this can be particularly confusing to some of our companies is if they've either started working with the university under a sponsored research agreement, or they're negotiating both a license agreement and a sponsored research agreement at the same time, because under a sponsored research agreement, that can be different. Often, if it's a collaboration where work is going to be done at both sites, both at the university and the company, then there can be mutual indemnification clauses. So just really follow the work, follow where the work is happening, as that's typically going to inform the indemnification. And this is definitely one of those places where any changes to the language around indemnification are typically going to be addressed at a higher level, and that address is going to be no. So I haven't seen that be changed. I would definitely recommend, save your time. We haven't had companies not be funded because of indemnification, as this is a very standard term in university licenses. It's an expected term. So don't spend a lot of your dollars or your attorney's dollars on this particular clause. And I've represented, just so you can see some standard indemnification language, there's a clause here. This is a pretty typical clause that indicates that over the term of the agreement and thereafter, that the company is going to indemnify the university. And then it calls out what we mean by the university. So that could be the Board of Regents or the trustees and students and faculty, et cetera. And then it indicates how that clause can be brought up. So again, highly recommend that if you have questions about that, just really think about where the work is happening. And if that really is mostly on balance at the company, or in almost every case, wholly on balance on the company, that's why this language is not going to be mutual. And now I'm going to have Nikisha, she'll be telling us about another risk allocation consideration, and that's around insurance.
Well, thank you, Lisa. So although it's been conveyed that there is a requirement for companies to indemnify the university, it's just simply not enough that an indemnity clause is included in the agreement. Universities must ensure that the licensee has the capacity to meet any claims that may result from its commercialization of a particular product. And this is typically done by way of the university requiring a licensee to obtain and maintain certain levels of commercial general liability insurance to cover those risks associated with the licensee's effort to bring a product to market. So why is this important? Well, what should happen if the university's technology is licensed and used even in the company's laboratory, and there is an incident in the lab where the laboratory practitioner decides to sue? So that practitioner is going to work with their attorney to bring suit against anyone reasonably or perhaps even remotely associated with the incident, which may include the university who has simply licensed the technology to the company, but for which the technology was not directly responsible for that incident. So general commercial liability insurance covers the company for anything that should happen on the company's time and dime. And from a legal perspective, although I'm not an attorney, if a company is operational, they should have commercial general liability insurance. And this is something that you should speak to with your attorneys. So the license may include some of the following requirements associated with general liability insurance. It may require that you use what is deemed a reputable insurance company. It may request that you provide a certificate of insurance to the university, and this is for verification purposes. It may request that you add the university as an additional insured. And this is something that may typically be seen by the startup or licensee as something that is onerous, but actually adding the university as an additional insured is not a significant additional cost. Please work with whatever insurance company that you may need to work with to understand those cost considerations. It may specify minimum limits of liability. So some number of millions per claim and some number of millions, typically larger in the aggregate. Again, the license may specify an amount of the insurance to be maintained, or it may say that it's a generally required amounts that are commercially reasonable. And I'd suggest, again, that you speak with your insurance carrier about what is deemed commercially reasonable. So in a situation where a technology will eventually be tested or used on or for humans, and once a product is being sold, the university will additionally require that the licensee obtain product liability insurance. And this covers any end user's use of the product and any adverse events that may happen by that use. Once again, there may be specified minimums based on the technology or product type. Specifically, low-risk products such as a software or perhaps a non-invasive device may require a lower limit than a higher risk product such as a drug or diagnostic. It's important to note that in general, the Technology Transfer Office may not have the ability to change the minimum limits of liability insurance amounts. As Rick mentioned, these terms are often set by the university's general counsel's office or the university's risk management team based on years of assessment of the types of risks that may result from licensing various technology types. I don't know if any of the team members here have anything additional to add to this.
So there are a couple questions. So a couple questions on insurance and actually one back on indemnification. So we'll start off with the insurance one since we're on this slide. So this attendee is curious about how many universities actually collect insurance certificates from their licensees. And I'll actually start off on that since I was, okay, so I'm seeing hands from our university members here. And I know that it's, when I was at Stanford, we absolutely collected them and we had it as an item in our database. It was something we invoiced for and we had to check off that we'd actually collected that insurance certificate. And obviously we kept that insurance certificate. So, but I saw Nikisha, you raised your hand too, that you do collect the insurance certificates. Okay.
Hopkins absolutely collects insurance certificates.
Okay. Yeah. And Lisa, yes. Yeah. And I think that something is important for people to know, and Rick, definitely comment here as well, is that there actually usually is often someone, especially in larger offices, but they're then otherwise, if not in smaller offices, there's someone's designated who works on compliance, basically compliance with the license agreements, make sure actually that, I don't know if we've actually even talked about this during this webinar series, but there is someone making sure that everything that is in the license agreement is actually happening. Now it's a big job. As you can imagine, each year signing more and more licenses, there is more work to be done, and there are possibilities of things falling through the cracks. But it's also obviously the company's responsibility to make sure that the things that are agreed to under the license are happening as well. And one of those is sending things in, like a piece of paper that shows, or an email or whatever it is, with an attachment that shows that this insurance has been obtained. Rick, was there anything you want to say on this, or? Okay, so next insurance question is that someone's actually running into insurance being unavailable in some Asian countries for startups. Any suggestions to mitigate this risk? And this isn't something I hadn't run into, so I'm just curious if any of you have any ideas.
I have not heard of that before. I wish I had more to add.
I haven't either. I'm sorry.
So if any of our audience members do you have suggestions on this, please either drop that into the Q&A or the chat. That'd be great for people to know.
Yeah, and just in general, though, people do tend to worry more about litigation risk in the United States, but it could be anywhere.
Yeah.
I've definitely encountered that in different countries, that country doesn't have the same feelings about insurance, requirement for insurance. And so we've had those discussions, but in those cases, they've still been able to find insurance.
Okay. So going back to indemnification, actually, this first one is actually related to insurance. Has anyone actually had to use their indemnification clauses? Have any of you in any of your experiences? No, not so far.
Yeah.
Okay, great. But as Nikisha said, I would think it was Nikisha. I apologize. It might have been Lisa. I can't remember now. Like the universities absolutely require these. This is part of their, like, they won't do licensing without this. So, and then also another question on this was about mutual indemnification. Under what circumstances can indemnification be mutual, particularly if a state university is one of the parties? Is this a drop dead issue? Lisa, do you want to go first, and then maybe Rick?
Sure. So that's what I was mentioning in terms of sponsored research and where the work may be done at both the university site and the company site. And especially if you're also having researchers from both institutes participating at both sites, then there are definitely times that can be mutual. And in terms of, is it a drop dead issue for a state institution, that I'm guessing you're relating it back to sovereign immunity, that public universities typically fall under if their state has that clause, which limits the liability or makes the liability zero. So yes, that can certainly come up related to liability and indemnification, but there are times where the university is recognizing that there's a more balanced risk, and so then they will have a provision around mutual indemnification. And if they don't, then have that discussion. There are times where it would be possible.
So I concur that mutual indemnification may be found in a sponsored research agreement, but not in a license agreement. And many universities very specifically separate these agreements.
So I have seen when people really want to go to battle on indemnification, I have seen different universities compromise on this. I've seen some state universities compromise to say, well, we'll indemnify you to the extent allowed by law, which may be not at all, but at least put that in there. And I've seen private universities when really get pushed to the mat. I have seen some that will agree to indemnification with limits. But it's not, I'd say in my experience, very few clients really feel like this is a worthwhile fight to have. And we're looking at what the risks are that the university could be responsible for, because indemnity gets to the idea generally that there might be third parties that get injured by the activities under this license. And then it's saying, well, if someone gets injured by the activities under the license, who's going to be responsible for that? And the more general type of risks people are going to be worried about in a licensing context are things like product liability, that an end user gets injured by a product, and then that end user, whoever gets injured by the product, sues everyone with a possible nexus to the technology, which can be, of course, the licensee and could be the university. Whether or not the university really will have liability or not, that's an interesting legal question, but the university may get sued nonetheless. And in that case, what the university is saying for in the indemnification section is, look, you as the startup, as a licensee, you're bringing product to the market, you need to be responsible for those claims. And we're not going to take any responsibility for that. And then backing that up is the idea of insurance, that you as the startup may not have, there might be product liability and you may not have the resources to pay those claims when they come in for the product liability, whatever it is. That's why we require you to have insurance as well, since if you're not creditworthy enough for those claims, so that the university is protected.
And then actually, so someone asked a question in the meantime, and then you kind of just answered it there, but I think there's actually more that could be added to it. Rick, there, it's what is the downside if there is no indemnification? And so you answered, I think, parts of it right there, but Lisa and Nikisha, do you want to add on some more about the downside of no indemnification?
I think Rick hit on a lot of it. If there is no indemnification, then the university is at risk. And again, it was mentioned before that many feel that because universities are large institutions, we may have deep pockets, but those deep pockets are typically allocated for researching university ongoing events.
I'm assuming the question was intended to be what's the downside of for the startup to not have it, because the university's got it. It's like, it's there. It's not negotiable. And I think the question is, what's the downside of the startup not having it? And it would be an assessment of the risks that the university could be exposing you to. And when you look at it, those risks are relatively few. I mean, it could be a risk that they that it got licensed to someone else, and that you find yourself in litigation with a third party on who actually has rights to the technology. So, those are the type of things, and those, I mean, that is a theoretical real risk, but, those type of things are going to happen very, very infrequently. And it's not, from my side as counsel to startups, I look at it as, is there really much risk here? Probably not. And is this going to interfere with you getting financing and getting sold? Probably not, because people aren't going to expect to see that indemnity from the university.
So we have two more insurance questions, and then we're going to move on. So one is, large companies are generally self-insured. When we're talking about startup companies here, so they are required to go out and get insurance, but large companies are generally self-insured, so you do require them to obtain external insurance. No, okay, that's an easy one. And then any tips on choosing reputable insurance companies? And I know, for example, like in the clause that we used to have, at least, and this was many years ago when I was in tech transfer, we actually had, there was a certain rating. There are ratings of insurance companies, and it had to have at least a certain rating in order for the insurance to be acceptable. But I don't know if there's other thoughts that you all have on that. No.
I think many times, not really. I think many times the agreement may indicate what that rating should be.
So look for that, but also, if you have other questions on that, usually your tech transfer office can point you to companies. We're not going to advertise any here, but also the attorneys you work with can point you to, and you just need to make sure that they have a very good rating associated with them. We have one more question, but it actually has to do with liabilities and their association with indemnification. So we're going to answer that hopefully under the limitation of liabilities part. So we'll wait on that one, but let's move on to the next slide, which is warranties.
Yeah. So now onto warranties, or perhaps I should say the lack thereof. So let's start with a definition. A warranty is a written promise or guarantee from one party to another of the integrity of something. So for example, that the facts are true and reliable. Warranties may sometimes appear in a license as a representation. Again, this may depend on the attorney's preference. Universities will typically disclaim all warranties. The reason is that universities do not place tight restrictions or corporate controls on how faculty and staff conduct research, and therefore the university cannot and typically will not make any representations or warrant anything related to the IP that's being licensed. And this may seem counterintuitive, but researchers do lots of different things that the university may not know about. The types of things will include whether or not we won't warrant that the technology will work, or if the licensor will be able to commercialize it. This brings home to the point that has been spoken about already today, that a commercial partner or licensee is taking a license and using a particular technology or invention at their own risk. Much like for the limits of liability amounts, this consideration is generally something that is policy driven within the university and managed by the university's risk management team or their general counsel's office. So again, we're talking about generalities. There are some universities that may provide some very, very limited representations. However, we want to make sure that we are informing you such that the startup is not surprised when a university disclaims all warranties. And an example clause is available here for you to review. Lisa or Rick, is there anything else that either of you would like to add?
There are, a couple things I'd like to add on this slide is that some university, you can get some reps to the tech transfer office's knowledge and some will allow that in a very limited nature, often just going to the rights to license and ownership. So that is something where there may be a bit of flexibility. But the bigger thing is just to underscore what this is all about, which is the university isn't making you any promises about the technology. They're not going to promise you that the technology works, that their patents are going to issue or be of any value, or that there aren't even any unknown encumbrances on the technology. And so I may be a little bit of a broken record on this point, but it is incumbent on the startup to do its own due diligence. And that's a topic we discussed in more depth earlier in the series in March when we talked about pre-licensing agreements.
Let's go on to limit liabilities.
Okay, so you may have noticed on that last slide how the warranty disclaimer was in all caps. When you see language that's in all caps, it's likely to be the warranty disclaimer or the limitation of liability clause. These are both clauses that are calling out to the attention of the reader that a party to the contract is in some way minimizing its liability under the contract. The limitation of liability clauses limit damage recoveries that can be obtained from a party to a contract. And they address two different kinds of damages in different ways. Contract damages can roughly be bifurcated between direct or general damages on the one hand, and indirect or consequential damages on the other. So let me give you an example just to explain the difference between direct and indirect. In a hypothetical example, a patent application gets inadvertently abandoned by the university after it was licensed. In that case, the startup can claim its damages are first that maybe it's gone out of pocket already tens of thousands of dollars or more for license fees and patent costs that have already been paid to the university. And then second, it may claim, well, we lost billions of dollars of profits because we no longer have the necessary barriers to be able to bring a product to market. And those are our damages as a startup. And so the out-of-pocket costs, the tens of thousands of dollars already paid, those are direct damages. Think of these as readily quantifiable actual damages or losses suffered by a party as a direct result of a breach by a party. And in this case, the loss is we paid this money for this license, but it turned out we didn't get anything for the license because the patent got abandoned. And some universities licenses won't even limit direct damages. And if they do, they'll put a cap on the amount. For example, it might say, your direct damages are limited by the amount paid by the licensee under the license. Now, the other claim by the startup that they lost billions of dollars of profit, these are indirect damages. And the startup is not out of pocket for this money. It didn't have to pay billions of dollars. They're just claiming that they would have expected to receive that amount, but now they can't because of this failure by the university. And universities' licenses will almost fully disclaim indirect consequential damages or lost profits. And this is a fairly non-negotiable position that the university is not going to be the insurer. They're not going to be able to take on that type of risk. And I'm familiar with one institution's policy where they actually had a damages judgment against them on indirects that were in the hundreds of millions of dollars. It ultimately got overturned, but there was a brief point in time where it was at risk of hundreds of millions of dollars for this type of damage. And as you can imagine, no contracts are going out from that university now without these type of disclaimers, but these type of limitations. But it's really common throughout licensing practice, and not just in university licenses, but in all kinds of different commercial contexts. So the main points of negotiation on these clauses are, first, whether they're mutual. And this is a place where there's flexibility. So on the indemnification, that's something where you're actually asking the university to take risk by being in a, by providing indemnification. This is a case where the startup is just saying, hey, you're limiting your risk. You're limiting your liability. We want to limit our liability also. And if we can't claim the billions of dollars we're going to lose in profits because of a failure on your part, the university shouldn't be able to bring a claim against us for the billions of dollars of royalties it's going to lose for some failure on our part. And so generally, universities will provide mutuality here. And many universities provide mutual limitation of liability for indirect damages in their templates, including Johns Hopkins and University of Washington. So thank you, Nikisha and Lisa, for that. And one fewer point that needs to be discussed when getting a license done. The second point of negotiation on limitation of liability clauses where there's any carve-outs. For example, confidentiality is a common carve-out. If there's a breach of confidentiality, the type of damages are going to be more of this indirect nature. So if there's a confidentiality agreement and a limitation of liability clause, it might mean the confidentiality clause is actually absolutely no teeth at all. So often there will be carve-outs. That is a common carve-out from limitation of liability clauses. Anything before we go to the next slide? So if there's nothing else to add there, now we've gone through the risk allocation provisions, and now we're going to turn to all things patents. And
would you do one favor for me, Rick, and just talk again about the differences and similarities between liability and indemnification? Because I think
sure,
get kind of
yep, absolutely. So they're getting at very different concepts. Indemnification generally is getting at who is going to take a risk for third-party claims, for third-party injuries. Think of it that way. There's a third party out there, and often it will be, it could be both a third-party injury, but it could also be like, a third party, a consumer, someone injured by a product, but it could also say someone who's injured because of the way the IP rights are allocated and they didn't get a license they were supposed to get or something like that. So it's a third party comes in the picture and starts suing people because they were damaged by the activity of the university or the startup. And the indemnification is saying, okay, in this case, the startup, you're going to take this set of liability. And it does get to a point of, often in indemnities, we will carve certain things out of the indemnity where the university should have been responsible. We're sort of saying, okay, we startup, we're indemnifying you generally, but not for things you messed up, university. So that's what indemnity is. Limitation of liability is simply allocating liability between the two parties to the contract. In this case, the university and the startup, and saying, okay, we're in a contract, and because there's a contractual relationship, under contract law, we can sue each other for different kinds of damages. And there's lots and lots of law on what kind of damages parties to a contract can incur, and in what cases they can collect those damages. And what these limitation of liability damages says, notwithstanding all those things that all these contract laws say, we're agreeing up front that you're not able to come after us for these kind of damages for breach of contract.
Right. Thanks. And then I have a question actually for our two university representatives. What is the incentive to actually have you agree to a limit on the startup's liability? Or is there? And I think this is something that it's a point that the startups bring up and sometimes do successfully, obviously, argue that there should be a limitation on the startup's liability.
I can field that one.
Go for it, Rick.
For someone who makes the argument a lot, and it went in, it's generally pretty well received, which is it's the incentive of the university is to be fair. And this is something that's very frequently brought up. And I mean, the reason I went through this experience, one of the universities I worked at, where we actually started with it just being one way. And we were asked so many times, we just made it mutual because, it's fair. We don't really have the argument. And just like, why, we startup can't go after you if you make a mistake and we're out a lot of our expectancy damages because we can't bring a product to market. Why should it be if you say we've done a failure, that we didn't properly market this technology or something, and you're going to allege that you got all these royalties? Why is that? That's just not fair. And it doesn't get, it's not like the indemnification section where the university is taking on risk. This isn't actually asking the university to take on more risk. It's simply saying, we, the startup, don't want you to come say that you lost a bunch of money. You know, you could have made a bunch more profits and didn't. That's
Thanks, Rick. I learned something.
Definitely that concept of fairness is a huge component of it. I'll say that like over my time in the office, that's one of the places where we've seen our contracts change. And that was to ensure that we were keeping in alignment with other good business practices. So not just university to startup, but business to business. And so I think, you know, that's definitely the way that our contracts have gone, have been, you know, how are business contracts in general changing? How can we ensure that we're being fair in light of those changes as that develops? And that's definitely, I think, some of that language came in when we were negotiating more with attorneys and VCs, and attorneys that represented VCs in particular, and understanding more about that neutrality.
And then a couple of other things that have come up. So someone actually shared some unusual warranty language that was put in. So I'm actually going to just respond to that. And I think everyone can see the answers to questions. If not, let me know. But someone, thank you for sharing that. And then, where is the carve out protection if, and actually, I think this may be coming up later. So I'm going to bring up this question actually when we get into the patent part of this. So, so let me do that for this next question. But we'll move on. Sorry, Rick, to ownership, or actually, Keisha. Sorry.
Okay. So ownership can be a complicated matter. However, in general, if the technology was developed at the university will own the IP and it will maintain ownership of the IP. So to ensure that a license is not interpreted as a transfer of the ownership of the IP, many licenses may include language that specifically states that this ownership will remain with the university. The university will additionally typically maintain control of patent prosecution. This may be different for prosecution, may be different from university to university. It's important to note that a license is different than an outright sale. In fact, the patent rights, materials, data, and know-how all remain the property of the university. And further, as noted in some of our prior sessions, the universities will retain certain rights in the IP so that they can continue with research. And again, a lot of this stuff has been discussed already. There may be joint ownership situations, for example, with another university or perhaps with another commercial entity, where the parties will have to, where the university will need to ensure that it has a right to further transfer the IP via a license. And many times, this is commonly done via an interinstitutional agreement between the joint owners, where the parties will agree on how the IP will be managed, who will lead prosecution, licensing, how the fees and revenue, if any, will be shared between those joint owners. And finally, the license between the university and the startup may reflect that information about the joint ownership in the recitals. And we talked about the importance of telling the story of how we got to the license. I would suggest that any startup ask questions. Again, this is going back to the very first 30,000 foot view. Ask questions about the ownership considerations related to each piece of IP. Again, this is part of the startup's due diligence obligations. And so I think Lisa and Rick will each have give us information on both the university and startup perspective related to patent prosecution.
Great, thanks. So as Nikisha just mentioned, the university owns, or in some cases, if it's joint IP, co-owns the patent. And the university is going to be overseeing the filing and maintenance of those patents, certainly the unlicensed patents. And then once that technology patent is licensed, the university will manage patent prosecution in conjunction with the licensee or licensees, depending on the technology. We get questions about that fairly often. And so I wanted to point out some of the benefits of having the university be the patent manager. And again, this is from the university perspective. So some of the benefits are the economies of scale. A number of universities, certainly the University of Washington, have extremely large patent portfolios. And with the volume of technologies that we have that are being patented and managed, that enables us to have billing arrangements with its law firms, have set costs, and be able to negotiate fixed billing rates. And what we've seen from our startups is that law firms often charge venture capital finance companies more than they charge universities when we have those fixed rates. And again, that goes back to the economy of scale. Nothing against the law firm, but managing one patent versus managing literally thousands of patents can just look very different. So that's one benefit that we can pass along to our licensees. Another is expert oversight. Definitely over my time in tech transfer, I've seen more and more tech transfer offices, including ours, have internal counsel and paralegals and really expert internal patent advisors. And so that can really save our licensees significant billable time through that management of really high quality patent prosecution through our office, as well as through our outside law firms. So another benefit, and also typically that time that's being used internally isn't billed back to our licensee. There's also, universities, there are long timelines here in terms of researchers being at the university. So a number of the researchers that I started working with 17 years ago, I'm still working with. And in a number of cases, we're still working with the same attorneys on their portfolios. So our licensees also get that benefit of that continuity of the counsel who were chosen because of their deep subject matter expertise. And that expertise only grows with their familiarity of the platform over time. And so that's been a big benefit as well. I've got the standard patent prosecution language that we utilize below. It's essentially saying what I just described, which is that the university is going to continue to manage the patents, but will do so in conjunction with our licensee or licensees, depending on the agreement. And what that means is when we have a new prosecution item or new time of filing come up, we communicate that out to our licensees. They're copied on the information that we get from our counsel so that they can see office actions when we are, or so that they can read through new patent drafts when we do. And then we take those comments into consideration from our licensees when we're responding to our attorneys. And I will say that one case where this can be different is if the intellectual property is joint with the licensee, then in many of those cases, the licensee will want to manage that intellectual property. And in almost all of those cases, the university will be amenable to that. So that's the university perspective. And I'm going to turn it over to Rick so he can talk about it from the startup perspective as well.
Except I'm going to first interrupt with a question, Lisa. So, and it actually, someone asked, is there a legal reason for the university to retain control of the patent prosecution?
So I think it's, partly legal, partly strategic. We definitely take the fact that we're the owner very seriously and want to make sure that we're doing our diligence on behalf of especially technologies that have been federally funded. So that's definitely part of what we're thinking about in the legal component. And then from a strategy perspective, and I'll say that this perspective has changed quite a bit over time as well. When I was first in the office, there had been concerns, not necessarily for our university, but just like sort of generally in the ether, that if you turned over prosecution to your licensee, that the licensee could direct the patent away from your technology, away from your ownership. And so that was definitely a concern on the part of many universities. And I think our language reflected that at the time. Oh, I will say that with over time and over just, I think, better communication, more relationship building between the universities and our licensees, that hasn't been the same kind of concern. And so there certainly are a number of times where from a strategic standpoint, we're making different decisions.
Thank
I don't know
you.
if anybody else wants to add to that.
Yeah, I have a couple points to add. One is that I have seen at least, state institutions make the argument that it's a state asset. And so that they have to maintain control of it. So I've seen that, taken from a legal standpoint, that needing to keep control. I have heard that. And I actually have one experience when I was on the tech transfer side of things where we had given control to a startup. The startup failed. It hired its own lawyers, and the lawyers wouldn't give us the files. And so the way when our lawyers say we didn't have to. So kind of learn from that one. So there could be, in interest like that, the universities are trying to protect. But from the I don't want to, and I don't want to diminish anything that Lisa said about all those advantages the universities bring, because they can have leverage in negotiating the fees with counsel because of the volume they're doing. They're often going to be curating counsel with deep expertise in particular subject matter. And as Lisa noted, there may be prosecution counsel who have long history of working with the specific inventors and understand the technology well. That said, there's two important interests, from the standpoint of the startup, and one is one has to do with just strategy and direction of the prosecution, and the other has to do with costs. And notwithstanding the benefits of using university's counsel, sometimes the startup is just going to think that they have better counsel, and they may be right, based on the counsels working with them on other matters, or maybe different industry expertise that's more relevant, and the commercial direction that they're going to take the product in. And so there can be instances, and I know my colleagues in this call have experienced this, where the startup will come in and want to actually have a different lawyer be involved in prosecution going forwards. And there's different ways this can play out depending on the practice of the universities. Some universities will be willing to switch lawyers, but will require that lawyer to represent the university. Some may allow for joint representation of both the university and the startup. And in rare cases, some universities will allow the startup to take over prosecution. And some institutions just simply don't allow that at all, but some have policies that enable that. And in the absence of working any of these other things out, the startup also can just hire its own lawyer to review and comment on the filing. And this happens, or they can even get more involved in draft filings and responses for the university counsel to use or consider using. This often isn't the best resolution, because then it adds cost, because now there's two patent lawyers more intimately involved. But sometimes this is the resolution to accommodate everyone's interest. In the third session, when we went through the term sheet, we discussed payment of patent expenses, including sharing among licensees. And these are important provisions for the startup. And for anyone watching today who didn't see our term sheet webinar, I would go back and watch a recording of that. I don't, just from a time standpoint, I'm not going to rehash what we discussed then. But the bottom line of it is the licensee, the startup, is on the hook for all past and future patent costs during the term of the license. So the amount and payment of those is going to be near and dear to the heart of the startup. I have a point on here about jointly owned patents, but Lisa already touched on that in the case of a jointly owned patent where the startup and the university are joint owners, in many of those cases, the startup will be given the opportunity to prosecute the patent in the names jointly of the startup and the university. And often the university is going to prefer this approach, because then it doesn't have to run the cost through its budget and then seek reimbursement. And
Rick, we have one question before moving on to
okay.
discussion.
One last point. I'll get to the question, which is that the patents can add up to a lot of money. It depends. If it's just a single U.S. patent, then that may be a manageable amount. But you can have several families. You can have international filings, and they can run into often hundreds of millions of dollars or even more. And the point of this is that the patent budget doesn't need to be a complete black hole for the startup. Prosecution counsel can provide a rough estimate of anticipated upcoming costs. So always encourage clients to request that information, and we'll often put a provision in the license enabling us to get that information. But even if it's not there, you ask, and you'll typically be able to get that information.
Right. So one other person actually did write in about that, and this actually goes on to Lisa's point about that the company can steer away the patent away from their product and then terminate the license, and that actually is obviously, hopefully not the relationship that you're building with the company, but that's another issue potentially with patent prosecution control, and that's a worry. Hopefully it's not happening very often, but that has happened.
Well, and I want to just make one point about that, which is, as long as the university keeps a continuation open, they can steer it right back.
Yeah, that's true.
I mean, generally, I'm not a patent prosecution expert, so there might be things tactically done during prosecution that can make that more difficult, but open continuations allow a lot of flexibility to get another bite at the apple.
Yeah. And then one other question for you, Rick. How do you preserve or protect privilege if the university counsel is not representing the licensee directly, but licensee personnel are talking to those attorneys?
Yeah, and I'm not an expert in privilege, but you can put in place common interest agreements that cover privilege. And actually, I think as a matter of course, we introduce that into licenses when it's not there. It's a good thing to have in the license, the common interest language, so at least you can, and I can't say whether those are always going to be enforceable and work, but definitely worth a try on that.
Yeah, and in general, I don't think, I mean, in all the licenses I've done, I've never seen that be an issue. So, but yeah, good question. All right, moving on to patent expenses then, Makisha.
Sure. So patent expenses or patent costs are all costs that are associated with prosecuting and maintaining the licensed patents associated with a potential product. And these costs are listed here and can include patent filing expenses and attorney costs. Notably, the costs associated, the attorney costs many times are more than the actual filing costs, because of the attorney time and effort. These costs, again, are regarded as a commercialization expense, and therefore it becomes a company expense. Most universities will require the reimbursement of all related expenses, including past patent costs, which are typically due upon the execution of the agreement. If the costs are expansive, the university may put a payment plan of sorts in place. Also, ongoing costs will typically be due on a rolling basis as they are occurred, and Rick mentioned that. Finally, as a precaution to ensure that expenses are paid, a university may require prepayment of certain fees prior to engaging the law firm to do the work. And as Rick mentioned, in these instances, this gives the company upfront information about the costs that are coming to them prior to actually incurring those costs. This means, however, that a company will need to be immediately responsive to the attorneys and the university, and also be prepared to make some early patent decisions so that you're not waiting to the last minute to move forward with certain patent prosecution issues. Okay. It's not unusual for licensees to actually resist. What's happening? I'm not sure what's happening here with my computer. I apologize.
No worries.
Okay. All right. It's not unusual for licensees to resist for paying for patent expenses. They may argue that patent expenses are the owner's expense and should be paid for by the university. They may also argue that it's prepared to pay the patent expenses, but only as an advance on royalties, so that any future royalties are credited back against those expenses. We want to assure you that we've heard all the reasons, and the universities will generally disagree. Again, patent expenses are commercialization expense and should be paid for by the licensee without any clawbacks. Recall that the university is not a commercial entity. We're not able to develop the products towards a commercial product. And further, we are not a bank. They are typically universities are state or nonprofit, non-commercial organizations, and we cannot be perceived as financially supporting the business of a commercial entity. This can be both for legal and tax liability reasons. Did either Lisa or Rick want to chime in any more on those patent expenses considerations?
Sure, just very briefly to emphasize that point. So the University of Washington's patent budget is a rolling budget, so that as part of it depends on being reimbursed for the patent costs that were proceeding. So our ability to continue to file speculatively is related in part to our ability to license out technologies. And so the fact that we have a technology to be able to be licensed is, partly due to our patent budget in general, but also due to the fact that that budget gets replenished as we're licensing technologies. And just one other point in terms of past patent costs. So this can come up often when we have a startup who's licensing an established portfolio, and there can be very large patent costs. If that happens and you're being asked to have that outlay at the beginning of the agreement, just know that most universities will put together a payment plan so that can be done over time instead of at the outset of the license, or they'll tie it to your first funding round of a certain level, things like that. So there is space to negotiate how those costs are paid, but don't expect that the university will allow those costs not to be repaid.
All right, we're going to move on to patent enforcement. Next fun subject.
Okay, and this subject is what happens if someone infringes the patents exclusively licensed to the startup. So the license has got the startup's got the exclusive rights, and then a third party out in the market is now infringing those patents. And from the startup's perspective, the ability to control enforcement of patents against infringements is the very essence of an exclusive license. The nature of exclusivity is that you are the only one who has these rights, and you could decide to prevent or allow others through sublicenses to use the patents as you see fit. And the first question to be addressed in the license on this subject is who gets the first shot at bringing an infringement action. And there's actually a lot of variations among universities on, well, there's sort of two flavors, the university first or the startup first, but there's a real split on that. Some university license templates do provide the universities get the first right to pursue infringers. So this can be an important point of negotiation on the license for the startup if it feels like it's important. It gets to control it. What I'd say in talking to different universities on this experience, a lot of universities' positions on this are colored by their previous experiences. So sometimes those previous experiences will make them very reluctant to allow startups to take it, no matter what I would think are the relative merits of the arguments on this. But it's an important thing for the startup to understand also, because as they're getting this exclusivity, well, what's it mean to have exclusivity if I can't enforce it against third parties? So it's an important thing for the startup to understand. If the university does give the startup the first right to bring the action, even if they give them the right and the contract says, hey, you can be the first one and you can sue them, the startup is actually not going to be able to bring a suit unless the university joins as a party. It has to do with what rights are necessary to have standing to get into court. And if they try to sue without the university, they will actually get thrown out of court under a typical university license because there's not sufficient rights. The standard is that you need to have all substantial rights, and the university license doesn't meet that standard generally. And so the startup will not have standing to sue. So another important point of negotiation or consideration in the license is whether the university is going to agree to join actions brought by the startup. And again, that's going to depend a lot on the university and what their policies, and maybe if it's a state institution, what some limitations are. And the final important aspect of the patent enforcement section is how proceeds of an infringement action are shared between the parties. In my view, there's a simple and fair way to do this, to come up with a split like 80-20 or 75-25, and have the lead party getting the larger portion and the startup having the first right to bring an action. Not all universities agree with me that this is the way to go, but often it's a compromise that's worked out. Sometimes there's very complex formulas. In my view, it doesn't need to be that way, but I know people have the different perspectives on this. And the vast majority of university licenses are not going to result in enforcement actions. I mean, this is a very rare thing to happen where people actually bring patent infringement actions. It's going to be like, some very successful licenses with large markets. But nonetheless, these economic provisions and what goes in the license are going to be important in case that does come up in a particular license situation. If there's nothing else, we'll turn it over to Nikisha to talk about patent validity challenges.
Sure. So the premise behind a university filing a patent application is to protect university IP and further promote commercialization. It's generally presumed that after issuance, a patent is valid, but patents can be challenged. Essentially, there are three components to patent validity under US law: novelty, utility, and non-obviousness. We're not going to go into the particulars today, but you can find lots of information out there. A successful challenge on any of these grounds will annul a patent claim and sometimes the entire patent. So universities, again, file patent applications and prosecute patents that they feel will be both valid and enforceable. Further, when entering into a license agreement, the parties should be in agreement that the resulting issued patents will likely be both valid and enforceable. Unfortunately, a licensee, sub-licensee, and or affiliate may, during the term of the agreement, opt to contest the validity and or enforceability of the licensed patents. To help manage these types of challenges, a patent license may specifically include provisions that address such a potential dispute. The first is that it'll make clear that royalty payments are to continue during the pendency of a challenge. So even though you challenge it, that doesn't mean you don't have to pay. Number two, that a licensee will pay for the attorney and university fees during the pendency of the challenge. This can be a very costly expense, and the university, again, is trying to protect its own budget. Number three, that an enforcement or a validity challenge may result in the royalties provisions to increase during the pendency of the challenge. And that may, again, be determined by universities' past experiences. Number four, it may designate the jurisdiction of the challenge based on, I guess, whether a university feels that it will do better in one area versus another. Number five, the license may result, the challenge may result in immediate termination of the agreement. And this in particular may happen if the agreement directly prohibits specifically a licensee from challenging the patents. It may be an immediate termination consideration. Number six, it will likely require that the startup provide notice of the challenge to the university well in advance of the challenge actually reaching the courts. And such notice may include a representation of the factual basis that the company has for the challenge, and additionally provide all related documentation to support that challenge. Number seven, finally, if any claim of a challenged patent is deemed valid and infringed by a licensed product, the agreement may indicate that the royalty increases by 2 to 3x or more for the remainder of the agreement term. So the rationale underlying many of the provisions is that the parties have entered into a contract, and those contractual obligations should continue until the contract is either terminated or expired. Additionally, and to reiterate, it's presumed that the licensee has performed sufficient diligence to determine if the licensed patents or patent applications are likely to be valid prior to entering into the agreement. Further, and very importantly, the licensee has very broad rights to terminate the agreement with notice under the termination provisions of the agreement in lieu of bringing such a challenge. And Rick has some additional comments related to the history of these provisions. Rick?
Sure, thanks, Nikisha. And so prior to 1969, you would not have seen one of these clauses in a license because licensees used to be stopped from challenging patents. So there was a doctrine called licensee estoppel that said licensees could not challenge the validity of patents that they licensed. And in 1969, in Lear v. Atkins, the Supreme Court of the United States invalidated the licensee estoppel doctrine. They ruled that the public interest in not having competition repressed by worthless patents was more important than the principles of contract law that may prevent a party from repudiating its promises under the agreement. So, Nikisha was talking about those important interests of getting the contract in place. And the Supreme Court said, yeah, but worthless or patents that were granted and really should not have been are a drag on the economy, and it's in the public interest for them to get invalidated. So the idea that a licensee can't challenge them, was discarded at that time. And then there was another significant change in the law in 2007. in MedImmune versus Genentech, where the Supreme Court found that a licensee had standing to challenge validity without repudiating the contract. So it used to be that if a licensee wanted to challenge a patent that had licensed, it actually had to breach the license, stop paying royalties, and then create a case or controversy over that. Supreme Court in MedImmune said, nope, you have standing. So in the wake of MedImmune in 2007, these clauses that you see here proliferated. And so it's very commonplace to see these. And I'd say, from a startup and a negotiation standpoint, generally the things that we will negotiate is just making sure they don't inadvertently apply. And like, we should be able to do things like defend ourselves in an action and that not, make the royalty go up 2 times. But, one thing I'd say about these provisions though, is we don't really know if these are enforceable yet. And the important public policy concerns that drove the Supreme Court in the decisions in Lear and MedImmune about wanting to encourage the ability to challenge patents that may be invalid, those could come up, if some of these provisions are challenged and could end up invalidating some of these provisions. We just don't know. The legal commentary on that, is mixed on these. And I'd say a lot of universities put these in, but some choose actually not to put them in just because of the uncertainty about their enforceability.
So, and I have one question on these. So someone asked about, what about depositing royalty payments in an escrow during the challenge period? Is that something that any of you accept? Okay. And Rick, have you seen that on any licenses?
I've seen it. It usually says the opposite.
Right.
And they're not recoverable. And I think I'd make it's not something we negotiate. And I think, the patent is the patent until it's overturned.
Right. Okay. I'm sorry, Lisa, you were going to say something.
I think that's fine. We covered it well.
Okay, great. All right, Rick, we're on to dispute resolution. And I know you have 2 slides on this, so we're going to go quickly through.
I'm going to make really short on this one. I don't have strong feelings about this. I mean, if the contract doesn't say anything at all about dispute resolution, that means people can go to court and, fight it out in court. That will, be sort of the default. University licenses are almost always going to specify their state as the venue for disputes. And it's not something I see. Some people will fight this. It's, I guess it depends what the state is, but, and maybe there is some compromise that if you have a real issue with the state, there could be, room for compromise, but it's not something I see that's fought successfully very often. Some universities prefer alternative dispute resolutions like arbitration, and to make that, work, it needs to be in the contract. That's kind of, there's so many arguments pro and con. I don't have a strong preference on it, but just make sure the things that are in there work. And there can be, just to make sure parties can seek injunctive relief if there is an alternative dispute resolution. That's like a lawyer nuance about, well, you go to arbitration, but there might be things you need to go to court in quicker to get some kind of injunctive relief or order of a court to preserve the status quo while the dispute's being resolved. And let's go to the next slide. I like talking about baseball arbitration, so I put a slide in there because you sometimes get to provisions in contracts where the tech transfer office says, no, we get the last word on this. We have to decide this. And the licensee's like, well, that doesn't seem right because we just may disagree on this. It may be like over a particular number that has to be reached. And a common place this comes up is in the combination provision where you have to understand the value or that 2 different components are putting into to allocate it. And in this one, the way baseball arbitration works is that each side submits one price or value to the arbitrator, and the arbitrator just has to choose one. They can't make a compromise. They can't come up with their own number. They have to choose one of the 2 submitted values. And it really encourages the parties to act reasonably, because if they put a far out number in, then they're more likely to lose it. And this is the way that salary arbitration works in baseball. So I like the mechanism. And I like looking for places where you get to loggerheads, because one party saying, no, I get to agree to this number. the university saying we get to agree, and this is one say, hey, let's use this mechanism. It's a simpler mechanism, and then neither of us has the final word, and we'll just say if we can't come up with this number, we'll kick it off there. And like I said, combination products is a likely candidate for that, and we have that, see that in a lot of licenses. It could be also that it could get into a question of like allocating sub-licensing revenue when there's multiple technologies sub-licensed. They're going to be, you know, to make this work, though, it has to be where you're trying to come up with just a single number that has to be agreed to.
It's a great point. I think it's an interesting one for universities and their startups to consider. So Lisa, we're going to go on to our last subject, which is name use. And then I have two questions still from the audience to have you guys answer, and then we'll wrap up.
Very quick. So use of names. This comes up often in the process of establishing a license. The licensee is interested in how they could use the university's name, or the researcher that created the technology, utilize that researcher's name in their marketing, in advertisements, things like that. And so while we completely understand why a company would want to do that, there are limitations. Importantly, though, the company can provide factual information regarding the existence of the agreement, but when it comes to the names and marks of the university and our employees, those other uses would require approval. And part of the reason of that is covered by the fact that the names and logos or identifiers of the university are often trademarked, but also that the university and the researcher are going to be very careful about indicating or having a use that might indicate some type of endorsement by the university or imply an endorsement. So if there are times where you'd like to use names, logos, etc., make sure that you contact the university. There are occasions where we certainly will allow that use, but that has to be agreed to outside the letter of the license agreement.
Great. Thanks, Lisa. All right, on to our last two questions. So one is about, I'm going to read it to you directly. It says, where is the carve out for protection if a third party sues licensee for infringement because the licensed IP overlaps with the third party's IP? Is that also a part of the limitation of liabilities? And so this is all about freedom to operate with the IP that is licensed, and how do the agreements then deal with the fact that perhaps there may be a third party that sues, and is there anything about limitation of liabilities under this? So Rick, I'm going to direct this one to you first, I think.
Yeah, so the university is going to accept absolutely no responsibility. The warranty disclaimer often will actually explicitly say, we're not telling you there's not other patents you need to practice this. This one is, and this is generally the case, not just in the university setting, that it's really incumbent on the party that's bringing products to market to do the homework to figure out, you know, if it's going to have freedom to operate, if other licenses are needed. This gets to I'd say of anything, a warranty disclaimer issue, where the university is going to just disclaim the warranty, so there's not going to be a cause of action against the university for this, and the university is not going to provide indemnity, absolutely not going to provide indemnity for that kind of claim. So it's really going to be, in most cases, 100% the startup's responsibility, and incumbent on the startup to do its own, diligence, freedom to operate analysis, whatever, to see if there's risk of that.
All right, and actually Lisa already answered our last question, which was about F1 visas and students, and they're working on their startups. So thank you so much for doing that. The answer to that question was in the Q&A. I would love for you guys to provide any last key recommendations, because we're at our time. But I know that there were some things that really each of you wanted to reiterate. So Lisa, did you want to start us off?
Any of my friends would know that I'm a proponent of never stop talking. So not just in agreements, but in life in general. But in this case, it's really important. We keep emphasizing the importance of the relationship. That is really key. Part of that never stop talking includes asking questions, reporting in, anticipate diligence, like anything that you can do to keep those communications open. Highly recommend. It would be a much better process for both sides.
Terrific. Thanks. Nikisha?
Actually, I have the same one. Open and honest, continued communications by both parties. This is key to getting things done and working with one another over the lifetime of the license. Because recall from the first one, the executing the license is only the beginning. You have a lifetime, almost 20 years or more, perhaps, that you're going to be in this relationship.
Thank you. Great. Rick.
My takeaway thought on this one is from the startup standpoint and the founder standpoint, the entrepreneur and the venture standpoint, is that the tech transfer office is your friend, and you should treat them like your friend, because they have a very complex job. And so they're carrying out the policies and practices of their institution. Maybe those policies and practices need to change, and maybe you can be an advocate for change by explaining your position, and things do change as we discussed. So, the tech transfer office is very aligned with the startup being successful and wants the startup, because the university gets nothing if the startup is not successful. So they'll be your advocate, they'll be your guide through the university, and it will be a relationship. There's going to be times you're going to go back and ask them for favors, because things are going to change. The license terms aren't going to work. A venture capitalist is going to renegotiate it. There's going to be new technologies coming out of the lab you're going to want to license. And it's, treating them as a friend and with respect and understanding this is a long-term relationship, it goes a long way. And I've seen the most successful CEOs who really approach it that way, with this idea of building trust and respect. And I've seen the opposite of CEOs just blowing up when they come in with a hostile, like, one thing I found being in the tech transfer office is like, it always seemed like everyone thought they knew how to do your job better than you did. And without realizing the complexity of universities. So that's my parting thoughts.
That's great. Yeah, definitely. Everyone's here to help, and everyone's here to build relationships, and definitely have built wonderful relationships. I already knew all of you before this, but this has been such a wonderful experience, Rick, Nikisha, and Lisa, to do this with you. Thank you so much. It's been a real privilege to work with you on this series. And to our audience, thank you so much for joining us for this entire series. We really hope this turns into something incredibly useful to the universities, to the startup companies, et cetera, and honestly to even to non-startup companies, and helping build those working relationships with the universities. It has been really fun for us to create this, and please do let us know if you have additional questions. I'm going to move on to the last slide, which actually shows everyone's contact information here. Feel free to reach out. They've already said you can reach out to them with questions. As you quit out of this presentation, you will have a survey. Please answer that for us. It's very short, 5 questions. We do like to know how people enjoyed this, what was useful, what would be useful in addition in the future. So, but thank you to our audience for joining us. And thank you again, Nikisha, Rick, Lisa, for putting together this terrific series.
Thank you, Kirsten, too, for hosting.
All right. Take care.
Thank you. Bye, everyone.
Stay safe, everyone. Bye-bye.